I'd like to call this March 1st meeting of the Oxford Planning and Zoning Commission to order. Start with the Pledge of Allegiance. Pledge of Allegiance.
United States of America, and to the republic which stands one nation under God, indivisible, with liberty and justice for all.
Roll call starting with Scott.
Joshua Dykstra.
Dan Ward. Lisa Brass. Pat Cotrell.
Brett Olber.
Jess Shermer.
Jessica Pinell.
Steve Gary. Kevin Sherry.
Do we have any commissioners online? Hearing none, I will seek Josh for Ed vote. So we'll start with Z-21-13360 Oxford Road, owner and applicant Holdings LLC, 15 Apple Drive. Proposed Dunkin' Donuts, special exception, Article 10, Article 7, drive-through window. And we will also at the same time deal with Z-22-014, applicant and owner, Pitcom Holding LLC, Attorney Dominic Thomas, 315 Main Street, Derby, Connecticut, proposed text amendment to zoning regulations, Article 3, general regulations amend, Section 3.24, parking general requirements.
We do have 2 emails that we received for correspondence.
Okay, would you read those?
Yep. So we have one email from Sue Arpin to members of the Planning and Zoning Commission. I would like to express my concern about the possibility of a drive-through for Dunkin' Donuts at the old Webster Bank site on Route 67. I live off of Great Hill Road, so coming from Seymour, I take a left at that light. Since Oxford Road is only 1 lane, when cars are taking that left, other cars that are going straight are passing on the right. If a drive-through was approved and there was a long line for the drive-through, there would be cars waiting on 67, which means that traffic would be stopped. As it is, traffic on 67 is terrible at certain times of the day. I cannot even imagine how it would be with a Dunkin' drive-through. It would be dangerous, and I anticipate there would be accidents. Therefore, I am asking Planning and Zoning to vote against putting a drive-through lane there, because in my opinion, it is unsafe and will cause traffic jams. Then we have a second letter from Eric Goldstein. Dear Planning and Zoning Board, I'm an Oxford resident, have been following the request by Dunkin' Donuts to relocate to the former Webster Bank facility at the intersection of 67 and Great Hill Road. I've read this in voices. I strongly oppose approval of this request. Being a resident of Meadowbrook Estates, this would create unnecessary traffic issues. Commuters traveling east on 67 would have to cross westbound traffic to enter and exit. People coming from Great Hill would have to intersect with the traffic from Dunkin'. We really don't need more traffic, and the potential for vehicle accidents is increased greatly. Customers in Dunkin' can walk inside the existing location and save our town from the potential traffic and accident possibilities. Please do not approve this request. Eric Goldstein, a happy Oxford resident.
Thank you. That's it, right?
Yes.
I wasn't aware, but we're prepared to go. You're going to be handling the special exception application tonight. I was under the impression that you were waiting until there was an action on the parking regulation, but we can address having it here tonight. Is that?
That's what I thought.
Yeah, that was my impression. I know you received a letter from Commissioner Curran requested the town engineer. He consulted, you received the letter. I received the copy.
Yeah,
That's on the text.
That's on the text amendment. Again, I made the presentation on the text amendment. I was going to address a few points on that, but are you also,
So which do you want to do tonight?
well, I think we're almost obliged to do the zoning parking regulation first, so we can address the parking issue. I can inform you as an update that with respect to the special exception, the applicant has gone ahead. He has gotten a traffic study. The study has been completed, is at District 4, and District 4 is reviewing it and will be getting back to us since it's a state road. So I can inform you of that. We certainly would be able to, we didn't bring the traffic engineer, and if you wanted even to hear from him, but obviously the traffic is an issue for DOT because it's a state road. So we are prepared to, we would be prepared to do that, for instance, at your next meeting, but I was under the impression that tonight was the zoning text amendment.
Okay, which involve parking.
Yeah, did we even start the special exception?
Oh, yeah, that was continued. The hearing was continued, we gave an extension. But the understanding that we had for when I first made the presentation was, we would continue it after the commission reached the consensus. Even if you hadn't voted on it, we could still proceed on it.
You'd be kind of surprised to go forward with the special exception first, based on what you told us last.
Right.
So then, let's not deal with Z-21-133 and deal only with Z-22-014 tonight, which is the parking regulation issue.
Hopefully you will, I know, we received a letter from staff on that.
That's from Nathan.
So we have one letter dated 2/21 from Jim Galligan, Oxford Planning and Zoning Engineer, to Mr. Patrick Quattrella, Chairman of Planning and Zoning Commission, regarding proposed text amendment for parking requirements. Dear Mr. Quattrella, Matheson Young Engineers is in receipt of the above referenced parking regulation amendment. The proposed amendment appears to focus on patron seating in lieu of gross leasable area. This approach ties the parking requirements to patron attendance rather than building square footage. As such, the amendment appears to provide relief for establishments that have large food preparation and/or storage and have smaller patron seating area. Conversely, the amendment appears to provide an increase in parking requirements for establishments that have a high ratio of patron to building square foot area ratio. These revisions appear reasonable based on today's consumer trends. If you have any questions, please do not hesitate to contact me. Very truly yours, James Galligan, PD, Matheson Young Engineers, Town of Engineer of Oxford.
Now, you want to?
Yeah, we met last week, the chairman and myself and Mrs. Pennell, and discussed text amendment versus the engineer's comment, town engineer's comment on the proposed amendment. And keeping with the trends and things like that, I was wondering whether the commission would consider looking at the cars that are in the queue, whatever that number may be. It may not be all cars, it may be a portion of cars, but a certain percentage of those cars being credited as being parking space on that site. So whether it's 2 spaces or 4 spaces, or whatever the number is, that would be another way of looking at it. It hasn't really been flushed out in the regulations, and the discussion that we've had around the text amendment, talking about square footage being attributed to number of patrons and things like that. That's certainly a good argument, a good discussion, but we should also consider what we're doing with the cars that are sitting in a queue line that essentially is just a moving parking space. So just another thought for the commission to consider.
Thank you. Go ahead.
Again, it's clear that I'm representing the applicant who's here for the Dunkin' Donuts, but this regulation addresses other spaces, it addresses other types of restaurants. And I think as Mr. Gowdy pointed out, it's sort of sort of addressing with consumer trends of each day. Certainly, if we were going to count those spaces and make a determination that you didn't need a parking change, then you would be interpreting your existing regulation. That's what I'm understanding. I mean, I mean, at that time, Commissioner Kerwin pointed out, the shared parking section, which has nothing to do with this. Even though this is a shared parking situation, it really doesn't have anything to do with that specific site. But in the shared parking thing, certainly this commission could decide that it needs to be bulked up a little bit. It does refer to the fact that the commission needs to present the evidence of peak parking times, which are the peak parking times for the uses, and different uses and requirements for safe internal traffic flow, which are the basic structure within the parking lot. So it can still be required for that. But if you wanted more, put more in. My focus is on the different types of restaurant and addressing the different business models. So, with the way the regulation was written, which is a one size fits all, it was actually prejudicial against those restaurants that are basically takeout, whether it's with a drive-through, whether it's a coffee shop without a drive-through, or whether it's a pizza place. You know what I mean? So that it motivates the other way. So that was our position on the generic thing, looking at it town-wide, without site specific. Because we get beyond this into the application, then we have to deal with site-specific issues such as the emails that you got. But I believe this regulation in general gives the commission an appropriate amount of discretion to address parking issues in commercial zones.
Commission, have any questions on this particular issue? Anyone?
I have a couple of questions and comments. One for Jerry.
No, go ahead.
So Attorney McSherry, how are parking spaces defined under the regs? We should have just talked about the 2.40. So it says parking spaces are space not less than 18 feet long and 10 feet wide required for parking vehicle.
Right, so this is it's standard what the measurement of the parking spots should be.
And parking is not a confusing term. It generally means not moving, cessation of movement to leave the car. And then there was a section 3.24 parking general requirements. It has for drive-through windows. It defines 5 off-street stacking spaces, which is how the regs define those particular spaces that are in the queue. So, just applying general principles of statutory construction, where you have regulations that define a parking space and a stacking space.
I think we
Does that
had
bother you a little bit with your
Yeah.
analysis?
Well, I think it does to the extent that I want the commission to consider those parking spaces as the stacking spaces. That's all I'm speaking to. I think that was not discussed at any particular point as a number of parking spaces. I don't think that was being considered. I understand what you're saying about the parking spaces sort of being a moving target, which they are if they're in a queue, but the regulation does address them.
And so my only problem, I like the idea, again, there's at a certain point, we can't just keep amending text amendments.
Exactly.
The regulations become plastic. But, I think it's important how we get around that. And if we come up with these kind of fictions that a parking space is not a parking space when it's a stacking space, but then it's a stacking space when it's a parking space. Don't you think that could be a problem with the construction as well, where we're not on sound statutory construction?
When you get to the point where you try to define things, yes, you have to then, you're better off with specific definitions. one of the discussions that we had the other day with the chairman and Mr. Canal was a discussion that was pretty much around that all these piecemeal amendments, all that does is cause you a problem, because one amendment here impacts 3 or 4 other things, and another parts of the race. It's problematic. So you're absolutely right.
That's my concern.
And as you say, it requires 5 stacking spaces. And there's, I believe, 14 total in the queue here.
Correct.
So
Well,
that
we
leaves
had
us
section
9 that we can call something else.
The problem with that, I thought about this. First, it seemed like it would be a good solution, but then you're taking away, so technically, if you're gonna let him take 9 spaces, the next guy can come in and just credit that queue line for his parking spots and have less in and out parking. So we wind up making the situation worse, smaller parking.
You know, that each application stands on its own. Right?
Yeah.
There's no precedent. So you can come in and say, well, these are parking spaces, but you don't have to acknowledge that elsewhere.
The problem is if you do it for one person, you gotta do it consistently. And when we start making these legal fictions, you tell a lie in one situation, it's a lie in another.
Well-
You can't, well, it's a parking space only for this guy's application, but here it's a huge one.
Okay, we're short, what? 6? We're short 6?
6 spaces.
6 spaces here. It's not a matter of that, you know, we're looking at, you know, we're gonna take 30 spaces and call the view.
My understanding, when it was first presented, this issue came up and we understood it. And the discussion was that they would go for a variance. And I believe the same arguments that you're making right now would probably work with a variance and would not require us then to get into this kind of tortured analysis. And we don't have to keep this kind of pell-mell text amendment going. He has the ability to apply for a variance. At that stage, if he's short of parking spaces, and he can make these arguments, which I think are good arguments, to apply. That would probably be a more regulatorily elegant way to resolve it, as opposed to coming up. Wouldn't you agree with me?
I think in the wording of the regulations, yes. Tortured is a good word, but I think that the struggle is with parking, and you have a fluid and changing commercial atmosphere with drive-throughs and things like that. They're always, you have to try to adjust to. And I have 14 cars in a line, and they're not parking. I don't know, I've been in those lines. I feel like I parked there for a long time. So you do have to try to flush out some more definition, as you're pointing out,
Yeah.
and make it a way to approve something and say, yes, it meets our regulations, and here's our check off. A lot easier for you to decide as a commission.
And one thing that I like the idea more of a more deliberative process. I think, there's going to be points where we do have to have text amendments.
Right.
I like the idea of maybe coming from us and sitting down and kind of banging it around a little bit. Use Dominic's language or the applicant's language as a starting point and see where we can go from there, as opposed to taking it as, and we don't have to. I think that's the important thing for the board to consider. We don't have to just take a text amendment as it's given to us. We can deny it with the idea we're going to come back and put a red pen through it and come up with some new sections.
I mean, you have an assessment from the town engineer that seems to say that from his professional opinion, that it is a text amendment that's certainly flexible enough that meets a lot of different criteria. It adjusts for sizes of restaurants, it's just for the use on the inside of the restaurant, for the number of patrons and things like that. So that flexibility is important. His analysis is important for the commission to consider. And to Mr. Kerwin's point, yes, it's a good basis to start with, and you can always add to the good basis to start with more criteria. Text
I was
amendment,
concerned about the engineer's statement about what's the effect on existing restaurants now if we do it. And I think that hasn't really been addressed in the amendment either. I mean, we have a couple of opportunities.
Can I address some of these concerns on this here? First of all, I mean, I'm a very good lawyer. I've created great arguments and hardships. I don't know what, honest, I'm going to be very frank. I don't know what I argue to a ZBA that this is a hardship under the regulations. The regulations are the regulations. the default position should be to take a look at a regulation and see whether that regulation is appropriate. You have a regulation that basically is a restaurant parking regulation that belongs, probably for restaurants that existed when I wasn't old enough to be in high school. That's wrong, kind of, because it's just a one flat type of restaurant. The business model has changed, and your engineer pointed it out. So the way you usually address a concern like that is exactly what I think we've done here. We've come up and made some, you don't have to take it word for word. Commissioner Kerwin had problems with the shared parking. Why did I put in the shared parking? Because when I looked at your regulations, I was surprised that you didn't have them. You thought it was too light, you could drop that one and put what you want. The restaurant ones are similar to what's in other towns. We're trying to address the type of restaurant, and it doesn't, the important thing about the zone change is that it doesn't require you to look at definitions of parking spaces and change them. It fits into the definitions of parking spaces. You don't change them, you have a definition. So the people that park here under these regulations, they are required. As far as existing restaurants, it has no impact on existing restaurants when you change those regulations.
Text amendment or Zoom?
Text amendment.
All right.
It's a text amendment.
Yeah, no, you
Is
said
that-
the zone change.
A zone text amendment, yeah, a text to your, a change to zoning regulation. Okay, so it doesn't have any impact on an existing restaurant and existing restaurants that are in shopping centers or something of that nature. At this point, under your regulations, you have multiple uses in a shopping center, except for the victim, the Cory Walk, which is under the victim. You simply add up all the different uses, and you don't take into account shared parking. Now, what would happen here, how this would impact it, is if you had a couple of restaurants go out of business and you had some new one come in, then they would be able to comply with these regulations, because you would be looking at the type of restaurant that's coming in, the space that it's occupying. It gives the commission, in my opinion, a sense of discretion to look at it, look at the type of business, which is what you need to do. Business models change. So, I mean, certainly going for variances, in my opinion, not part of economic development. I mean, the variances when you have to vary it and you show a hardship. We lawyers in the land use area often say that 80% of the variances are probably illegal that's why the statute is being changed hopefully during this legislative session. But the appropriate way is to approach it with this fashion. I mean, the fact of the matter is that right now you have a single line, one thing for restaurants. It's making a difference what the use is, what the business model is. So all I did was try to address it, which doesn't require you then to go and look at your parking regulations, your 9 foot by 18 foot or anything like that, change any of that. You still got to comply with all that. So that's, I think, is the more appropriate way to go from a zoning perspective. I know commissions, applicants have the right to make suggestions, and the commission has the right to change them if they think it's on the right adequate. I think that, you're more than welcome to change it, but I think in order to move, and I'm being very honest, in order to move this project forward under the regulations, that's what you have to address the parking issue, because the parking issue doesn't take any account to the type of restaurant that we
Does anyone on the commission have any questions at this time? Brett?
I like the fact about using text amendment changes more than the variances, because text amendment is clear. It's very distinct. It tells you exactly the way, what our expectations are. And the applicants, no matter who that is, no matter what business they're proposing, they know what we're looking for. A variance requires somebody to come in here and make an argument. And if somebody in one day can't make a clear argument that somebody else can make clearer 3 weeks down, 4 weeks in the future, that other person may argue the same variance and they may win out simply because they argued better. Versus if everybody had the same regulations to follow. I think that's where the text amendment changes, in my opinion, are more clear. So we should spell out as much as we can in these text amendment changes. So I like text amendment changes. I know we have some leeway as far as like, exactly what we spell out in here. But my opinion is this is the better approach to go with these text amendments versus just asking for a variance.
Is there anyone else?
Just a quick comment. I'm not soliciting a variance from you or suggesting it. I thought you brought it up.
No, I don't,
You were talking-
I mean, that,
At the
I
first
may have said
hearing,
the only other option is variance, but I don't know where the hardship is. There's no, what is the hardship in the second? Plus, if I was successful, I don't know how happy I'd be if I came back with a variance for 14 space, having all 14 spaces considered as parking spaces. I don't think that would be beneficial to the zoning impact. It is correct.
Tom, it was my question. So I wasn't suggesting that that was the method you're gonna take, or I was responding to the comments about how you were short on parking spaces.
Yeah.
And that you were, I thought you would mention the variance, but
I'm a preference of addressing appropriate zone text changes.
Do any other commissioners have a comment or question?
Just a couple more things. Under the current design of the Dunkin' Donuts, how many parking spaces are required?
Are we going back to sites, the other application?
Oh, you're right, my mistake.
I'm sorry.
You're right,
Yeah.
you're right.
Thank you. Okay, is there anyone in the audience that has comments or questions about this? Is there anyone in the audience that has a comment or question about this? Is there anyone in the audience that has a comment or question about this? Hearing none, back to the commission. Anyone online have a comment or question on this? Yeah. So it's back to the commission, anyone?
Yeah, then I got a problem. I mean, another thing is I'm thinking about the parking. You don't even bring the automobile, right? What I did is I went down and stood around 67. I picked up, something like these everybody has. Nobody's been changed to these commercial vehicles that are parking all over the street now. You're saying, we're using one restaurant that we're talking about reducing the parking.
Give this.
Yes. You take the, comment one. You take the first page, it's 10 days on those announcements.
Is this on the text amendment or is it something?
It's done both, it's gonna be on both. That's when it came down, the application coming up, so I'm not actually sure if you can. We're gonna have to get that application also. This study was taken by the Yukon Connecticut Crash Data Respiratory Crash Study, Department of Transportation, Public Safety. On Route 67, there was 268 accidents. And on Great Hill Road, it was 22. Those are two, and that's the major dangerous high intersection from Oxford. You can take a look at the pictures that I had taken. I put up those at town real quick. So many. The first picture is that school bus on the side of the roadway. First one, that school bus on the side of the road, it's on Great Hill Road. With Dunkin' Donuts and there now and Ion Bank. You're coming out of that parking lot, you're gonna get blindsided, you can't see. Go to the next page. This is the problem with Great Hill Road and 67. Where you got a right-hand turn coming off of 67. With that truck there, you can't see coming out of Great Hill Road taking a right. Go to the next page. That's a small truck and tractor, the next one. It's a straight traffic tractor trailer. They just look at the pavement underneath the truck. We're spending millions on a Main Street project, and We don't see this in any other town. And this is because of lack of parking. No state in consideration, these commercial vehicles go into a call for 14 parking spaces. We call about cars. You're not talking about a contractor that has 4 guys in the truck and goes to a served window. It says, give me 4 sandwiches and 4 coffees, and you got a trailer behind you. Now you're gonna back up traffic. Coming out of that area there, you won't be able to take a left at certain times of the day. And the next picture about these vans is commercial vans that we got. These are the size of the trucks that are parking in. This is what we're concerned about. When we talk about messing around with parking and talking about reducing spaces, you know, you gotta take into consideration these commercial vehicles. There are guys that work all day, they want a cup of coffee, they want a beer, they want something, sandwich, they're gonna park where they have to. The other one's a perfect example with a dump truck inside the parking lot. You have no place to park it inside the park long ways. And the last one's that tractor trailer. This guy here, I watched it for 20 minutes, sitting drinking coffee and eating a donut. With no regard for those cars coming down 67 or coming out of Bridge, they'll go take that right hand turn. But that's my major problem, about adjusting any kind of parking, reducing any parking spaces. Not just, I know drive-throughs are coming. Because of the pandemic, they're gonna get popular. But the fact is, we gotta put them in a safe area. We just can't control any place, especially on that dangerous intersection.
Thank you. Thank you. Is there anyone else on the commission? No. Dominic, you want to sum things up?
Well, again, that was a site specific. You know, I can respond to it. We have a traffic report that addresses it, that is going to the state. And when we have the hearing on that, we'll present to the traffic report, because the state's making the determination. Certainly, and I've said this to many commissions, not just here, you don't base the decision. First of all, the regulation that we presented is a parking regulation. The one thing I can look at in the pictures generically in parking is you see a lot of empty spaces in the pictures. So obviously you have an abundance of parking. So, you know, by changing the regulations and addressing it to the business models, I don't think that impacts the traffic whatsoever. Or traffic is another issue. Traffic is an issue that is dealt with on a case-by-case specific basis. In your regulations, for example, for this type of a regulation, you have a requirement for special exception. You have a requirement to ask. So these pictures show people violating the law. I don't think people violating the law, not every one of them, but most of them do. You should park the school bus there, you should park trucks, you know, on the highways. Those are issues you don't violate it because people aren't, you don't overlook a regulation because people are going to violate the law. That had nothing to do with parking. I mean, some of those people, the big trucks, you might say they couldn't pull in, but certainly if a big truck wanted to stop and go to Fritz's, or wanted to stop and get a coffee at the Dunkin' Donuts that exists in the shopping center, they pulled into the parking lot, tried to, or pulled into Fritz's and walked across the street. There are things that they could have done, but those anecdotal things don't impact whether or not you should change your parking regulations when you look at them, when they're one size fits all and all isn't the same. So that's the benefit of mine. When the time comes now for a site specific, then we will address them with the traffic engineer. And as the law is clear, both in the appellate court and in a recent case by Judge Berger, traffic engineers are engineers. And while you can look at things anecdotally, I'm not a traffic engineer and you're not traffic engineers. That's why the traffic engineers get paid for their advice. And so we will address it at that time. My position is that the antidotes here is something that we will have to address, but in a site-specific situation, I don't think it affects it.
Can I make a motion for this?
I'll second that.
There's a motion on the table. Okay, we have a motion on the table for closing this public hearing. We have a motion and we have a second. All in favor?
Aye.
Opposed?
I want to hear what you guys say.
That's good.
You guys have.
Okay, this public hearing is closed. The commission has 65 days to make its ruling. Thank you. Thank you.
Mr. Chairman, just a procedural.
Yes.
If you wanted to address any amendments to and this is through the chairman to our council, what would be the appropriate step for the commission to take? Addressing- Yeah.
That would be during deliberations, I would say.
Yes, during deliberations, you would make any comments, additions, deletions, if you wish. And then the
The
commission.
fact that they haven't been brought up in the public hearing would not prohibit us from making those.
Correct.
amendments.
Correct.
Yeah.
Thank you.
Mr. Chairman,
Yes.
for the previous public hearing or the first public hearing, when is that recessed till? I wasn't sure if you have a specific, if the commission has a specific date in mind.
That's- If you are going to consider this and reach a consensus at the next public hearing,
Meeting.
Uh-huh.
At the next meeting.
at the next meeting, I'm sorry, it's the next meeting, then, my client can be ready to present at that, assuming there's a consensus, in favor of it. I mean, the problem is we have to deal with the parking issue, you know what I mean? So, and for frank and honest with you, we do have an issue with the respective tenant timeframes, but that has to take a back seat to your actions, okay? So whenever, if you need another extension, we'll be glad to give you an extension. I wasn't involved in the beginning, so I haven't done my mathematical computation as far as the number of days that you need a further extension.
We do need another extension. I'm not exactly sure what the number is. There's other considerations as well. Even if we were to approve it at the next meeting, which is March 15th, yeah, it's in March, right? If we did that, the regulation really doesn't take effect
Well,
immediately.
there has to be an effective date. So even if you presented, would you still, there,
I mean, we
I
could
would just happen to be researching where, in fact, we can still present under that. You just can't approve it until the regulation takes effect.
Right, so there's a time there as well.
Which actually you probably would be approving on the same night we heard the
Right, you
arguments
wouldn't
anyway,
be
so,
saying that anyway.
so the timeline can be maintained.
So, Mr. Chairman, I say we get an extension to our first meeting in April, which I believe is,
Don't tell me April 1st.
no, that's a Friday, but we're okay.
No, February or March, use that.
I think it's April 5th.
Tuesdays.
April 5th, that would be fine.
April 5th?
And I'll, Jessica and I can count the days and I'll give them an appropriate letter.
Perfect.
Thank you. Okay, moving on. Have Z-22-015 applicant owner Mark Delory. Attorney Dominic Thomas. Proposed text amendment to zoning regulations, Article 5, new, Section 5.3.5, Article 10, new, Section 10.1.2, amend Article 17.2.1. Correspondence for this?
Yes. With a few letters that we received. The first letter is from Anthony San Angelo to the Planning and Zoning Commission, to whom it may concern. Tonight, I attended the P and Z hearing regarding the Laurier 81 Newgate Road. Those who spoke had some valuable points that need to be addressed, i.e. traffic, residential noise, residential zone, noise, and liquor. I have attended functions and also visited the horse farm. I am in support of this text amendment and feel this change can be an asset to the country atmosphere of this community. In the Valley area, catering halls that can accommodate large groups have diminished. Restrictions in the text amendment can be in the language. For example, security for enforcing noise, liquor, and traffic. Or 2, liquor license permittee with liquor liability. Change has already come to Oxford, making it a desirable town to live in. Farmland has become residential subdivisions, leading to an increase of cost to education and roads. Business growth leads to increased grand list, tax revenue to keep the mill rate stable. Sincerely, Anthony Sanangelo. To the P and Z Commission from Teresa Maltese, to whom it may concern, tonight I attended the public meeting on this text amendment, would like to use this letter as my platform to show support for Mark Laurier. I first became aware of this property when I attended an event there, and I was impressed by the owners, their care of the property, and their awareness and respect for their neighbors. I subsequently took my 4-year-old grandson to the horse farm and stables, and he had a wonderful experience. The owners live on this property, and their vision and hard work is evident. I feel they surround themselves with people who have the same integrity, and I totally support this text amendment and feel this would be an asset to the growth of the town. Sincerely, Teresa Maltese. Whom it may concern, I, Alexander Kolka of 7 Sunrise Drive, Oxford, would like the commission to know I am in support of the proposed farm bill that's before the Oxford Planning and Zoning Commission. Having lived and owned a business in Oxford most of my adult life, I find the charm of Oxford's agricultural atmosphere to be most relaxing. Modern farms need a way to supplement their businesses with modern ideas. Supplementing the farming business with agri-entertainment makes sense. Farms need another avenue to generate revenue in order to remain relevant and to maintain their open spaces. Again, I encourage the Oxford Planning and Zoning Commission to pass the current farm bill before the committee. To whom it may concern, I am in favor of the farm use zone change. I'm in favor of the farm use zone change. I have lived on Good Hill Road for 21 years. Several subdivisions went in along Good Hill Road. The traffic increased tremendously. Don't stand on the road on a sunny weekend when boats, jet skis, and people are heading for Jackson's Cove. Plus the summer concerts at night. Don't get me wrong. I think it's great that people are enjoying themselves. I never complain. That's great. For a farm to offer their acres for weddings on summer weekends in a very small event, on summer weekends is a very small, if any, impact on traffic or the roads. A farm needs ways to keep afloat. It is better to have a farm with acreage than a 20-lot subdivision in its place. That will have at least 2 cars per household and to be on the road almost every day. Don't forget about barking dogs or loud trucks next door. A farm is a win-win for everyone. Oxford is a great place to live. John Quoco, 185 Good Hill Road. To whom it may concern, I, Tracy Stella, would like the commission to know I am in full support of the proposed farm bill that is before the Oxford Planning and Zoning Commission. Some of my best memories with my son Ethan as we were growing up was going to local farm and enjoying the atmosphere. Being able to pick fruit, take a hayride, enjoy a weekend event where we could mingle with our neighbors or the occasional birthday party. Merging the use of a farm with its traditional feel and blending it with more modern purposes is nothing short of brilliant. It allows the residents to enjoy the farm atmosphere with quality time of our loved ones. Again, I encourage the Oxford Planning and Zoning Commission to pass the current farm bill before this committee. And then we have a letter from, is this something right? No. From Peter Olson.
Jessica? This letter from Peter Olson, is this already read in or is this a new?
Is this a new one?
This is a new letter.
Okay. Patrick Coach, February 24th, 2022, Patrick Coach, Chair of Planning and Zoning. Dear Pat, this firm represents Jennifer Camaro and Eric Bernardo, residents of 37 Reality Road. At the February 15th, 2022 public hearing, we presented our opposition to this application and requested that the commission deny it. The purpose of this letter is to summarize the legal basis for the commission to act to deny the application. General statutes 8-2 and 8-3 grant statutory authority to zoning commissions to adopt and amend zoning regulations. In exercising this authority, you act in a legislative capacity. Konigsberg versus the Board of Aldermen of the City of New Haven, 283, Con 53581, 2007. Acting in such legislative capacity, a zoning commission is free to amend or to refuse to amend its regulations whenever time, experience, and responsive planning for contemporary or future conditions reasonably indicate the need for or the undesirability of a change. McKenzie versus Planning and Zoning Commission of Town Monroe, 2013. General statutes 8-2 provides standards and requirements for zoning regulations. These are generally referred to as the normal police power purposes of zoning, and I encourage you to review those standards and requirements. In reviewing an action on a request to amend the zoning regulations or zoning map, the test of the action of the commission is twofold. One, the zone change must be in accord with a comprehensive plan, and two, it must be reasonably related to the normal police power purposes enumerated in General Statutes 8-2, Sum versus Zoning Commission of the Town of Ridgefield, 1962. A comprehensive plan is a general plan to control and direct the use and development of property in a municipality or a large part thereof by dividing it into districts according to the present and potential use of the properties. The requirement of a comprehensive plan is generally satisfied when the zoning authority acts with the intention of promoting the best interests of the entire community. Morningside Association versus Planning and Zoning Board, City of Milford, 1972. Notably, while the plan of conservation and development adopted by the town every 10 years is not the comprehensive plan referred to in these cases, General Statutes 8-3A requires that you cannot approve any zone text or map amendment unless you state on the record in writing the manner in which the amendment is consistent with your plan or conservation, your plan of conservation and development. I hope that the foregoing demonstrates to you that you are free to deny this proposed text amendment well within your authority as a zoning commission. Contrary to the statements of the applicant and members of the public who spoke in support of the application, it is not the case that your hands are tied with regard to this application. You are not required to provide a zoning framework to allow the activities in which this particular applicant has been engaged. Activities which violate the current zoning regulations and are therefore illegal and not permitted. Most importantly, farming and the right to farm do not provide unfettered rights to engage in any activities desired by the farmer. We support the right of farmers to make a living by engaging in farming activities, and even to engage in farming activities which are not economically profitable. We do not support the expansion of uses which are commercial in nature and belong in commercial zoning districts into the residential zoning district, which makes up most of the town. We again ask that you act to deny this application. Should you have any questions, please feel free to give me a call. Sincerely yours, Peter S. Olson.
That's it? Okay. Before we proceed, I want to read something here. When a planning and zoning commission amends zoning regulation, it acts in a legislative capacity. And then it has a site, Ron Kari versus Planning and Zoning Commission, bunch of numbers and stuff. Amendments to the zoning regulations are allowed by Article 18 of the Oxford zoning regulations. A text petition filed by the applicant requires a public hearing and eventually a majority vote of the commission to be approved. This particular text amendment is not site-specific and impacts the entire town. Properties that meet the requirements of the text amendment, if adopted, would be permitted to apply for a special exception. The proponent of the text amendment would be able to apply or a special exception for the proponent's property if the text amendment is adopted. Our regulations have significant requirements and must be met in order for a special exception to be granted. There would have to be public hearings on an application and testimony heard from all interested parties. I am reminding everyone interested in this application for the text amendment, that the impact of the amendment must be viewed in the light of the impact of the amendment on the entire town of Oxford. Look for, oh, okay.
Thank you much, Mr. Chairman, members of the commission. I'm here to respond to the comments that were made at the last public hearing. And I am going to not respond to all the comments because many of them are site specific. So they're not directed to this. It may run across the line and give me an example every once in a while, but I'm going to respond. I'm going to respond by beginning at the end. I listened to Attorney Olson, who I have great respect for, and I listened to his presentation. And I do not recall myself or anybody saying that your hands were tied with this regulation. As a matter of fact, the statement of Attorney Olson that you're acting in your legislative capacity is correct. Your hat changes. Your hat goes from the administrative capacity to your legislative capacity. You have broad discretion. And the things that he points out are very important. And you or your staff, the public hearing should be your staff normally, not independently you, should do research. So part of it in addressing a zone change, a text change such as this, is, if you remember, I presented you the regulation at the time of Griswold, which was sent to us by the Connecticut Farm Bureau, who had also sent a letter about this issue of agri-entertainment, this issue of how to address the economic issues of farming. And I picked up the phone and I called the planner. It's a very interesting conversation. Your staff might want to do it. To some extent, it's a little bit apples and oranges between Oxford and Griswold, but in some ways it's not. In talking to them, the main purpose of what they did was to do the exact same thing, to create economic basis for the farms. They have one large entertainment area on one large farm, and there are other farms talking about it. And he was interested to hear that it was being considered in Oxford. Griswold, like here, and I will get to it with some of the exhibits that Attorney Olson presented to you, is predominantly residential district. And a lot of them, Oxford calls it RA, residential A zone. A lot of them, like Griswold, Monroe, other towns call them RF zones, residential farm zones. I know I've dealt with some cases. Whilst familiar with Monroe, I have a couple of cases there, and they have RF zones. And I'm in fact in the two towns involved in RF zones, which address the farming issues. But we have discussed it, that it's not site specific, and I think it's very important that you address it from that perspective, that you're looking at this for the perspective of the whole town. Now, I passed out a couple of things to you, and honestly, the two things I passed out to you were similar things to the same things, I should say. The map that I presented to you is basically the two maps that were given to you by Attorney Olson. I just put them on a 11 by 17. Okay, so that you can see them together like this. And I did it for a reason. The left-hand map, and I thankfully was able to click the buttons on my thing to bring out that gray pretty good. And what that is a DOT map showing which roads are feeder roads. And he was using it that Newgate was whatever the categories are at the top, that certain roads are arterial roads and everything like that. And I then made the zoning map, which he presented to you, to show you that, as you can see, Oxford is very yellow. it happens so yellow and blue are popular colors right now supporting Ukraine, but Oxford is yellow here because that's your predominantly residential. The deep yellow is, of course, the residential golf district. Your farms, the vast majority of them, if not all of them, are in the yellow. So if you're going to address anything with respect to farming, you're going to address it in the residential district. And the farms, based on a case that I'm involved in right now in Oxford, having gone back to 1930s using the famous magic Yukon aerial photos, there were a lot more farms than there were houses. So, and it's very interesting, especially when you're looking at the area where I lived in Oxford. So what I was doing with these maps is to give you that picture. That the fact is that Attorney Olson made a comment that, if you were to pass this, it shouldn't be in the residential zone. Well, then there is nothing other than the residential. There's very little other than the residential zone, and you don't have farms in the industrial area. So, the fact of the matter is you have to be realistic. You have, as he said, the discretion to zone. The comprehensive plan is sitting in front of most of you. It's your regulations. That is what the comprehensive plan is. And if you couldn't change the comprehensive plan, well, of course, then you couldn't change your regulations. So in his letter to you, Mr. Attorney Olson pointed out that you can change the comprehensive plan when you act as a commission to pass a regulation that you determine is in the best interest. Now, that regulation, yes, has to have some relationship potentially to the POCD. The POCD is an advisory document. But if you said it isn't in the POCD and it isn't in our regulations, therefore I don't want to amend the comprehensive plan, then you would not have the Village Center mixed use district. And you wouldn't have Corey Wall. Because this commission took a step that turned out to be a brilliant land use step by changing the regulations with, for those of you that were around then, opposition. But you took the courageous step. I'm not trying to equate this to being a courageous step, but I'm saying you've got to be sensible in looking at it. So he points out that when you do that, you have to consider the best interest of the community. You have to consider your police powers. You have to do that. So one of the ways you do that when you're changing the uses within the zone is that you address it by how those uses are implemented. So you would never take this regulation and allow it to be done by site plan. Because when you allow something to be done by site plan, and this has been confirmed by the appellate court recently in the Northwood case, you then make a determination that the entire infrastructure surrounding in that zone is able to address, is able to sustain that use. So for example, if you had a farm and that farm became a 40-lot subdivision, you could ask that developer to make improvements to the road along the farm. This subdivision. You could not ask it to make improvements at an intersection a mile away, because you've already made the determination that in the zone, in the residential zone, because it's available by subdivision, which is a matter of right, you don't, that's fine. You can't ask them to do it offsite. You do it onsite meaning on the road. So what in this proposal, we made a special exception with substantial standards to address, which gives you the option to consider those. So don't think it's open-ended, your hands aren't tied or anything like that by this. In fact, as was mentioned in the preamble about zone changes, you have to go we have to go to a second application. Then Attorney Olson gave you a single page. And I passed it out to you. First, the page he gave you from your POCD was the first page. He was, and I had the same problem. He was complaining that his color printer didn't work last time. Mine worked, so you see the pretty picture of the farm. And this is the agricultural land. This is from the 2007. I'm sorry, 2016 or 18 POCD, effective 2018. You know what's interesting for you to do in your research? Go back and look at the 2007 POCD. The 2007 POCD has similar language in this page. It talks about Oxford's longstanding agricultural heritage. It talks about the type of land. It talks about the dairy farms. It talks about that it's important to the flavor of Oxford, and the rural characteristics of the town are important to the residences and businesses. Doesn't talk about farms becoming subdivisions. It talks about trying to do something to maintain the farms. In 2007, the POCD discussion of agricultural land ended at that point. In 2009, the town of Oxford passed the right to farm ordinance, one that many others have adapted. In 2018, you have under the goals, policies, and recommendations of environmental preservation goal, we have a couple of comments that I did not find in the 2007 one. One is to preserve the agricultural resources as an important component of the community. That language was in there in some fashion. And then on the next page, on strategies, you'll see there, in short, the zoning regulations do not prohibit the operation of a bona fide agricultural operation. The commission should consider permitting, quote, farm stores, close quote, and other agricultural related uses by special exception in the residential zones when conducted in conjunction with an agricultural operation. Now, that doesn't say to allow them to have weddings or family events or anniversaries or even fairs, holidays. It doesn't say that. What this does is this shows that in what Attorney Olson pointed out, that you need to look at your POCD for advice. In 2018, he was giving advice. What was that advice? You need to look at other options to preserve the farms. As one of the letters read in there said, they would prefer farms over subdivisions. And in many towns, they are fighting to preserve farms over solar farms, solar displays. So the fact of the matter is that, and I'll go along with Attorney Olson's letter, your POCD does contain language that you can rely on in acting on this. But it doesn't specifically talk about that, but it talks about the fact that the need for some economic benefit. You're not reinventing the wheel here, okay? This is being done in other towns, and they are grappling with it and passing regulations. There were other comments that there are 175 parcels of 20 acres or more all over town, and I think the implication was you'd have 175 weddings going on at the same weekend. No, there'd be a lot of people get married. But the point is that not all the 20-acre pieces in Oxford are farms. So you have to be a farm. And you can't just plant a couple of stalks of corn and claim you're a farm, because this commission isn't going to accept that. Okay, so it's got to be, it's not a situation where somebody has 20 acres and they're going to just say, yeah, I'm a farm. No, you have a definition of a farm in your regulations. He pointed out that the wineries, the farm wineries, can take advantage of the reg. That's correct. Frankly, the very first version of the farm winery that I drafted, which eventually formed the basis the client took it on himself. The very first regulation that I drafted and discussed it with it had a similar thing, allowing wineries, if they had sufficient space, to have weddings or other events, as long as you had a tent outside and you provided adequate parking, as I put in the regulation. But yes, they can. In the regulation that's proposed, there are numerous standards and numerous protections. He also made a comment about waivers. He said you can't have waivers. Well, honestly, when I was sitting there last hearing, I was scratching my head. What's he talking about? Waivers? Well, what he was referring to is in the regulation, which was similar to what I put in the original draft of I think the document, the farm wineries. In the regulation is a statement that on 10.2, the proposed 10.12.4, the site plans in accordance with shall provide that the commission can waive the requirements of an existing site structure infrastructure. So for example, if a farm came to you and one of their buildings in the farm was within the setback, but it pre-existed, you could waive that requirement that building might be used for something. Certainly, if you didn't like that, you could take it out, but it was in there only to protect existing farm buildings, not to protect new buildings or new uses, because the regulation provides that they have to show you where the event space is, so you can determine how it impacts in each separate area. The was a talk about enforcement, which when I heard it, I thought it was a little offensive to your zoning enforcement officer that he wouldn't be able to enforce anything. I think he can enforce things and he does enforce things. But there was talk about the noise ordinance, and possibly I may have put it in the wrong decibel level for residential, 55 instead of 45. And he pointed out the regulation. It's 45 at 1 foot on the property line, or 1 foot beyond the property line is the regulation in your noise ordinance. And I want to explain this, Kurt, because it happens in other towns. It happens in a very popular, long-standing, month-long, 3 times a week, multiple times a week, whatever it is, Halloween festival that they have, where it runs through the woods and there's parking. You can require, under a special exception, that anybody who gets an approval from the special exception to do it, you can require that they, under the regulation, that they have to provide noise, for instance, if they're going to have music, they have to provide on-site noise monitoring and present it. You can require that. That's not an unlawful condition. Number 2, if they are crowds that are large crowds, you can require as part of a special exception that the applicant, the property owner, and this would be passed on, of course, to the individual, provide private, not private police, but provide police services that they would be responsible for, not public police services. They would have to special duty a police officer on the site. You can provide that, and that happens. You're not inventing the wheel, reinventing the wheel with that. That is a requirement in some of these type of situations to define it, because they are in rural areas. By its very nature, if the farms are going to have agri-entertainment, they're in rural areas, and most of the farms. Stop and think about it. Drive up to Jones's during pumpkin time, strawberry time. Drive up to Fairview. Drive up to other places like that. They're in rural areas with residential areas. And when they have events, a lot of times they're required to drive to Beardsley's to pick apples in September, and you'll see a police officer out there being paid for by it. So you have the power to do that. These are the protections that are written into this regulations. I'll end in my responses for this with, I thought was, I smiled a bit when this was brought up. So a realtor stood up, an individual who identified himself as a realtor. When he said to you, what if you pass this? What is he gonna have to do when he brings someone in to buy a house that's near the farm, a farm? He was obviously being a little site specific. And his point was that I'd have to tell them, do you know that you could have a wedding? You could have a party, and at 8 o'clock at night, you could hear music. The first thought that came to my mind, that if he is bringing a prospective purchaser to, right now, before you pass this regulation, if he's bringing a prospective purchaser to buy a house that overlooks the farm, does he say to that purchaser, I want you to know, by the way, that while you're living here, you have no ability to object to odor from livestock, manure, fertilizer, or feed. That the noise from the livestock or farm equipment is normal and generally acceptable, and you can't object to it. And that dust created during plowing or cultivations or the use of chemicals appropriate and in accordance with the regulation, you have no objection to that. Does he read that to them? Because that's in the right to farm ordinance. So does he tell them that you're living near a farm, a working farm? In situations, that could be a farm where there are horses stabled and there are maneuvers. There could be a farm where there are deer guns going off at 4:30 in the morning. It could be a farm where the plows go in. It can be a farm where the maneuvers go. That's what you, when you want to live in a rural area, that's what you do. What we are saying here is that the issue of placing some agri-tainment with great limits, and the limits that are in here, for instance, limiting larger parties to 10 times a year, limiting them only from May to October, those are precautions that you can make. Then requiring a special exception. Keep in mind, I don't have to write the considerations of the special exception. You already have them in Article 10. So when somebody comes in and it is a site-specific consideration, you can consider that. You can require them to do the various things. Because, number one, at this point, you're wearing your legislative hat. And number two, when you do a special exception, you're wearing your administrative hat. But you have broader discretion in this section. So I think, again, it's not my job to address this, the site-specific ones, which if you pass this, I'm sure we'll be addressing them. Yeah. So any questions?
So we have a list of 10 people who signed up to make a comment. When you come up, please state your name and address for the record. First person is Kathy Johnson.
Thank you. Well, it's a complicated issue.
Name and address.
Okay. Kathy Johnson, 68 Dorman Road, Oxford, Connecticut. As many know, I'm very fond of horses, and there are horses on that piece of property. The only thing I can say is I don't know all the legal aspects of this, but I have been on that property. It is a huge piece of property. As a matter of fact, I attended a birthday party there of a woman who actually gives riding lessons on the horses there. So it is a huge piece of property, and we had, yes.
You're being site specific.
Oh, excuse me, I'm not a zoning person, so I'll be site specific. Well, all right, just as a layperson, I didn't see a problem with that, but my most concern is horses. And the fact that they can still operate there. And I'll leave it to you experienced people to figure out the rest of it. But I wanted to speak up for the gal that does do some lessons there, and I think she lives on the farm. So I promised I would say so. Thank you very much.
Thank you for your input.
The next person I think is Jean Branson. Is there a Jean Branson?
Yes,
If you could come up to the front, please.
I signed the paper not knowing that that meant I was supposed to speak.
Oh, that's fine.
But I have a letter that I can present to you later.
you want us to read it into the record now?
If you would like to.
Sure.
Oh.
I thought it was in cursive first. Very well written. Town of Oxford Planning and Zoning Commission. I inherited property off of Laborde Road, which merges with Newgate Road. It has come to my attention that the owner of 81 Newgate Road has been,
Why don't we just put it into the
Yeah.
record? We have the ability to disregard it. It's not
It can be-
germane to the text.
If it's presented, it's put to the record. It
Yes.
doesn't have to be read.
the next person is Brian Walsh.
Please address.
My name's Brian Walsh, and I live at 39 Wheel Road. I live within a mile of 2 farms in Oxford, and I support the text amendment. My family made a home in Oxford in 1999. I grew up here, I eventually bought a house here, and then I started a business here. I did this because I grew to love the town for what it is, a small farm town where you probably run into someone you know on just about every road. If you look up the history of Oxford on the town page, the first line reads, originally part of Derby, Oxford was first settled as a collection of farms. These farms are our history, and we should make it possible for them to adapt to the current agricultural trends. We need to support our farms so that the history is not all they are. Thank you for your time.
Thank you.
Keith Rusty. Name and address.
Keith Ruskay, 12 Surrey
Okay.
Lane. Without being site specific, I'm just here to support our farmers and our farms in Oxford. And I just want to lend my voice in support of the text amendment as written. Thank you.
Thank you.
Michael Serrano. Or Serrano?
Exterior 3 Summers Lane. I used to live at 60 Newgate Road, right across the street from the
Not
property.
site specific.
I came here in defense of the farm. I want to keep it as a farm, keep the land as it is.
Thank you.
Leslie Alexander.
Thank you very much, Commissioners. Leslie Alexander, 25 Reality Road. I do understand that when I spoke here before you 2 weeks ago, I was site-specific. So now I'll make some general comments about farming and our community. I was almost a farmer in this community and had great support to become a farmer here. I have many friends in this town who are farmers, who raise llamas or alpacas or goats. So I don't want it to be misconstrued that I stand before you tonight being against agriculture. I think the farms in Oxford, it's one of the reasons we moved in. We've been here for 20 years. We came out of Rockland County. If you know Rockland County, New York, there were 500 farms before World War II. When we moved out of Rockland County in 2005, there were only about 10 farms left. My concern about the farms is that they want to make this a commercial enterprise. All of agritourism is often focused on what is happening at the farm. Tapping maple syrup, having beehives, riding, seeing your horses. I understand all of that and support that wholeheartedly. What I don't support is any place in this town that is interfering with the quiet nature of the residential housing that is here. The second point is the roads. Our roads are terrible, not just around the place that I'm not supposed to name, but throughout the town. There are dirt roads and small roads. The amount of traffic, we heard from the people who presented their letters about Dunkin' Donuts, 67 in Great Hill, and those are much larger roads than are in most of our town. So I don't want to take up too much of your time because I appreciate you giving me an audience. However, I think that you have to take strong consideration to what a farm actually is and when it's being turned into a concert or wedding venue. That even though it's a beautiful bucolic setting and there are horses there and forest, it's still a commercial enterprise. And we have commercial industrial zoning. Thank you very much.
Eric Granato.
Eric Granato, 37 Railway Road. Just basically second everything Leslie just said. It's very tough to be non-site specific, but in general, I brought up my points in the past about the EMT in this town, along with Paul Schreiber and Gordon Granolini and David Ives, the police officer that got me into being an Oxford ambulance EMT that I volunteered. And my letter that I originally wrote after hearing the ambulance call go out to Steve about an extrication still sits and makes me sick. And I still feel that having people who are inebriated, having people who don't know the roads in this town, to go back a couple years, we had the Shop the Pool or whatever event that popped up out of nowhere. And the big complaint on all the Facebook pages were, these people are drunk driving around our town and they don't know where they are. These people don't know the roads. Anyone going to a wedding in Oxford doesn't live in Oxford. These are out of towners. These are people that I'm afraid we're going to hear more people dying, getting hurt, all that other stuff that goes along with it. I'm actually just telling myself with, I'm livid, but it's hard for me to express myself further right now. I appreciate your ears, your honesty, your time, and everything. I am not against agriculture, as my attorney said. This is just, it seems to me like some sort of an Instagram type moment that anyone who in town can afford over 20 acres of land and eventually buy a couple of horses, call himself a farm and turn it into a wedding venue. So thank you for your time.
Thank you.
Jennifer Camaro.
I will say, my predecessors.
Name and address.
Jennifer Camaro, 37 Walton Road. I won't be site specific. I love farms. I go to farmers market. I buy eggs up and down different roads around here. I love farms, like horses. I think the idea of farms being able to have farm activities and horses and maybe even farm products like some produce, maybe eggs, honey, meat, fresh meat. That's amazing. I absolutely support that. I would love it if this tax change meant that we would have more places that did that. What makes me uncomfortable is the broad text change with the broad requests in it that really don't specify that these are agricultural and farming activities. These are opening it up for, and it is in the text amendment, so not site specific, but it does say for large catered events, X 100 cars, X 100 people. So that would apply across the board. Granted, I'm sensitive because I might live closer to one of these places than other people. That's a lot of noise. So I think if we can support farms, I'm all for it. If the farm in question was selling eggs, I'd go there. We're not talking about horses and eggs and honey and petting ponies. We're talking about making this change to open up the doors for much larger commercial type activities. I'm against it. I'm totally for farms though. Love the farmers market. So just to be clear about that, all not farms. Thank you. I have 2 other letters that folks sent in. You don't have to read them, but you can.
Final person on this list, Bridget Romagna.
Oh, I'm sorry. Sorry.
Bridget Rebecca, 28 East Street, and I'm in favor of this text amendment. I grew up in Oxford and I've lived here all my life. The farms in Oxford are a community character. When our kids were younger, they went with their school to pick pumpkins and go on a hayride to see the cows at Shriver's Farm. Shriver's Farm has held large events such as the medieval times and rented out their fields for years to supplement their income. I love that we can still drive by Shriver's and other farms in Oxford, enjoy the open fields and views, and it's not another development. I would like to comment on a couple of things that were previously stated by speakers in opposition to the approval of the text. It was stated that South Farms and Morris was shut down due to the noise from weddings. While they no longer hold 500 people attending professional concerts, South Farm still hosts weddings on their farm to this day. Other farms near Oxford, that rent out spaces for special occasions and weddings are March Farms in Bethlehem, Windcrest Estate in Bethlehem, Winbian Farms in Morris, Woodbury Barns and Farm, Royals Farm in Torrington, Wood Acres Farm in Terryville, Candlelight Farms in New Milford, and Castle Hill Farms in Newtown. Okay, the second concern was the traffic and the drunk driving on Berry Road and Good Hill Road. Jackson's Cove holds large summer outdoor concerts, and residents are able to rent a pavilion for special occasions with alcohol successfully in the same vicinity with no complaints or objections in the past from the community. Your time.
Thank you. Is there anyone else who would like to speak that hasn't bothered to sign in?
Chairman, thank you. Michael Hurd, 152 Good Hill Road. I have a farm right next to Mr. Delori's, and I'm not going to be too specific to his place. But pro agriculture, I have the farm right next to his. But what I do look at is that this particular text amendment has an awful lot of vague statements in it. And I don't think it's conducive to residential use with only 20-acre parcels. My particular property has 3 immediately adjoining me, and then another one across the street that are of that size. And immediately down the street, there's several more. These properties are all over Oxford, and it could be a shotgun blast of having people come in, set up small farms specifically for the purpose of getting a catered location. We have Villa Bianca could just go, all right, we set up a little horse stall, and now we're agriculture, and we can move on to putting a catering event. So I think between looking at roadways and sizes of property, and then we also have the music and sound system. Nothing has been addressed about that in this text amendment. And it's not necessarily about specific decibel levels. It's about a steady music and sound of a crowd and or announcements. And from our property, the particular one that is already existed, you can't hear it. I have a piece of property, 2 properties adjoining, and I'm planning on building a house for my retirement there. Now I'm having to reconsider where I would put my house because of the possibility of having continuous weekends of having music and announcements going on next to me. So I think those kind of things need to be really looked into on something like this. And then again, as well as what was just mentioned, is about our roadways. I don't see anything in here really about being very specific about how the roadway is. So my property comes out on Newgate Road. There's 5 blind corners and 2 blind hills on Newgate Road because until just a few years ago, Newgate Road was a 1.5 lane dirt road. But when the town went to fix it up, the properties had already been bought up. There's ledge piles that couldn't go into people's properties. So the road was fixed up as best as they could. That's the way a lot of these properties are sitting on roads like that across us. So I think you should take a very concerning look at those kind of conditions. And they either need to be worked into the text, or maybe this text needs to be completely revised. I don't think it's really written for Oxford. I think something could be done, but
These are my reasons here. You have a copy of this letter?
I have one.
Got enough there? Yeah.
Thank you very much.
Yes, does anybody else in the room?
Oh. Mr. Chairman, I told Peter Olson, he is waiting to speak if, when you're done with the public, but I did want to let you know. Because he
Okay,
has.
okay.
All right.
Michael Walling, 224 Moose Hill Road. Somebody's talked about real estate people when they talk about selling a house near a farm or whatever. Every time there's houses across the street from our farm on Moose Hill Road, the real estate people put it in their ad that it's right across the street from a farm. So they use this, use us, our little guys that try to keep our little farms going, to get more value in their houses. So that being said, it's obvious that people want to come to Oxford and they want to see a farm here and there. Oxford was all farms. You have to remember that. And economics made it, we grow houses instead of corn. And we took away all the farms. We should try to keep as much farming going, whatever it can be. There's one other point I'd like to make is there was an event, horse events are just awesome. It gets the kids involved. I had the opportunity to go to a horse event. And it was a couple of the Oxford kids that invited us. And when those kids compete in that ring with the barrel racing and all the parents are there and they're cheering them on and everything, it's an awesome thing to see these kids of all their horses and they're really proud of their horses and their animals. And they grow in responsibility because they're taking care of these animals. And they have a lot of fun out there and you're not doing something else. You're there on farmland enjoying what they do. There's one thing that goes on at these events that just stirs my heart. And that is in the beginning, everybody stands up and they play the national anthem. And a horse and a rider will come out with the American flag and run around that ring and go a little faster every time as the national anthem is being played. That just sends shivers right up and down my spine every time I experience that. That's America. And it's wonderful to see that. And we're seeing it right here in Oxford. We need to promote these kind of things, especially for the kids today where they've got this kind of a venue to work with instead of what all other kids are doing. There's so much of everything else out there for the children these days. Let's promote these kind of things and whatever farms we have left in Oxford. Thank you.
Thank you. Is there anyone else? Time, please.
Tanya Carver, 1 Winston Road. Evening, everyone. Thank you for the opportunity to speak. And I was a member of this board a few years ago. In regards to the text amendment, I would like to see that the acreage of the farm be the same as we've done for the winery. If on these activities, we're going to have alcohol and it says that in the residential zone, same requirements provided for fine wineries. So let's make it consistent. We did it for wineries to be 50 acres. That's something that I would like this commission to see. So it's consistent. You're serving alcohol in the residential area. We're asking the wineries to do the same. We're also asking the wineries to have plenty of space for parking and that there is adequate road access in and out. Thank you.
Thank you.
My name is Mark Delorier, and I live at 81 Newgate Road. 25 years ago, I bought a 35-acre farm. I didn't buy it to hunt the land. I didn't buy it for room to ride recreational vehicles. I didn't buy it to develop it or even set up a shooting range. Bought it to farm the land. Farms have been a part of Oxford since its beginning. It's a fact that farms are no longer what they were 100 years ago. Farming has changed for many reasons, and farmers have had to adapt or evolve with the times. Some of these changes that farmers have had to make are with agritourism. Examples of this can be found in Oxford with the sale of ice cream, wineries, production of slab wood and harvest lumber, pony rides, animal petting outings, clinics, and various other forms of entertainment. It was brought up at the previous meeting that farmers survive. I couldn't agree with this statement more. You can't remove the knowledge and experience from a farmer, which is what makes them who they are. The fact of the matter is that while farmers survive, farms don't. Everyone has seen photos of picturesque abandoned barn relics with beautiful rolling prairies in the background. What's not clearly stated in that photo is that before there was a picture, there was a farm. You don't have to travel far to witness examples of this. We live in an area where decaying properties are quick to be transformed. Just because we didn't witness the barns come down in front of your eyes doesn't mean that it never happened. Here in Oxford, farmland has been transformed into industrial complexes, a church, schools, shopping centers, and even an airport. I'm not condemning growth. Every growing town needs these amenities to sustain itself. Growth is good. It's good for towns and businesses alike. It's also essential for farming. Farms can grow with the installation of proper regulations. There are people in every town that want to say that they are from a small farming community. They just don't want any farming activity. You cannot have one without the other. The best thing to come from farms through agritourism is simply life in the raw. Only at a farm can you see the fields of stalks before the cobs of corn, the cow before the milk, the hay before the bale, chicken before the egg, or the egg before the chicken. There is no other place where you can experience these sights other than a farm. These experiences build memories for everyone involved. The greatest reward of farming isn't a banner year for your crops or the birth of a new foal. It's the expression on the faces of the kids and adults alike getting to experience life in the raw with you. Please help Oxford Farm survive for the residents of Oxford and surrounding towns. I support this new farm text amendment and encourage the committee to do the same. Thank you for your time.
Thank you.
So I also have to submit 15 individual letters from different people in town and 406 signed petitions that I would like to submit for the record.
Good evening, thank you for hearing me. My name is Lenny Alexander, I live at 25 Reality Road. I heard all night people love farms. We all love farms in here. And we love farming. We have friends that we moved here that we have because they have farms. When friends come up, they visit the animals, they visit the plants, they visit the whatever could be done. But nowhere, everyone in here tonight loves the farm and they love farming. What do weddings have to do with farming? What are other activities to do because your farm is not working? I feel for the people who've lost their farms because of big farms were taken over. But if you're going to go build a wedding venue, that's not farming. People don't come to Oxford to see wedding venues. That's what I have to say. Thank you.
Thank you. Anyone else?
I've been in Oxford since 1971. I've watched the farm be turned into houses, industrial stuff, shopping malls. When I came to Oxford, there was a couple of things on Main Street, that was it. I know that growth is important, but I also know that farms are seriously important. People come to the farms to enjoy the scenery, the animals, the people, honest, hard-working people that make their living the hard way. Like Michael said, the kids come, the parents come. My life, I grew up, I mean, I was born in Waterbury, you know, when my dad decided to move here, I was like, oh my God, I'm gonna move to a farm. That farm that I moved to, because my parents didn't own it, they rented it, is now like 5 houses. The next farm we moved to in Oxford is now a whole bunch of factories and breweries in that section of town. I don't want to see that happen. And I think that the trend for farmers is to find another way to make money because farming doesn't pay. It just doesn't pay. You can't have cows anymore because they pollute the air. You can't raise pigs because they make too much noise. You can't have chickens because if you get a rooster, your neighbor complains.
Yes.
Okay, so what are farmers supposed to do? They either have to make a living or they have to sell. And believe me, Oxford's a beautiful town. I love it here. I love the people here. I love that I can have my horses on the property. And I do make a living with my horses. It's a hard living. I'm not rich. These are the clothes I wear every day. I'm not walking around in diamonds. Well, I tell them I work hard. The people on the farm where I am work hard every day. It is beautiful. And the people that come up the driveway are like, we can't believe it's like heaven. And that's why they want to get married there, so they can go home and say, this was like the best place I could have ever picked to get married. I'm gonna have the best memories. And, you know, I know that might be site specific, but the fact of the matter is there's many sites in Oxford that are no longer existent. That when I grew up, I couldn't wait to go and see and be. Thank you very much.
Thank you. Is there anyone else? Come up, please.
My name is Robert A. Petnella. I live at 4 Anthony Pond Road in Oxford. 22 years ago, I bought property in Oxford. Since then, I moved here, my children moved here, my grandchildren are being raised here. I think this is a great opportunity for our children to have opportunities to have a place to go as family. Family is probably one of the most important things to all of us. Okay, I think it's a great opportunity to keep people together. I'm also a realtor. I sold property in this town, built homes in this town. And they all want to be around the farm. They all want to keep their families together. This is an opportunity to do that. I think you ought to consider it. The world's full of problems. Let's make our problems a little less difficult.
Okay. Is there anyone else?
Ray Stan, I live at 140 High Back Road in Oxford. And I'm all for this. I just want to say that I've known Mark for quite a few years. He's done a beautiful job.
Please don't be site specific.
What's that?
Please don't be site specific.
All right. I think this is a great thing for the town. And I think, I don't know if anybody here would remember Jesse Dunn, who owned the property before. Owns it now. But she would love it the way it's being done. It's a beautiful place. My granddaughter works on the horse farm there, and I think it's a great place for the kids to work. I think it's a wonderful thing for this town, and I do
like the fact that he's keeping it open space and not selling it off and building houses on it and making it a whole bunch of houses. All for it. Thank you.
Thank you. Is there anyone else? Is there anyone else here? Okay, well, is there anyone online who wishes to speak? Well, yeah, but the other and the other.
Peace reasons.
Okay. Attorney Olson?
Thank you, Mr. Chairman. This is Peter Olson. My letter earlier identified that I represent Jennifer Camaro and Eric Granato. So that continues to be the case. I apologize for not being able to be there in person tonight. I really only have one comment to add to the discussion that's been had so far. The applicant, for I guess obvious reasons, has repeatedly invoked the term farm, farmers, agricultural to try to gain the sympathy of the board for the use that they currently engage in. But meanwhile, the actual application, when we talk about a catering venue that can handle 300 individuals, is not agricultural, is not a farm, and is not being run by a farmer for agricultural purposes. It is in fact a commercial venue that would not be permitted in the residence zone on any other property. What the applicant is requesting is that you allow some property owners in the Residence A zone to engage in these activities that are commercial in nature, that belong in a different zone. And if you are to approve this application, what you will be sanctioning is the destruction of the farm that they are trying to protect, because they will have converted it into a commercial property. And so as much as individuals decry the loss of farming properties in our communities, and that is definitely a loss that we feel, you should not let that framework dictate your decision here. Now, I'm obviously only talking about the wedding venue. There are a number of other uses that are authorized by this that are farming in nature. And so one of the speakers talked about equestrian events. You know, that's great. That's an agricultural use that augments the existing agricultural use, and we're not criticizing that. It's the attempt to slide a commercial catering venue under the rubric of claiming it's an agricultural use when it really is not. Thank you very much for your time.
Thank you, Attorney Olson. Is there anyone else online that would like to speak? Is there anyone else online that would like to speak? Okay, hearing none at this time, I will take any questions or statements from the commission. Anyone?
I just had a few comments. It's not good. I think the main takeaway that I'm hearing is the need to support farming in the community. And I fully agree. I moved to this town 30 years ago. My wife is from Oxford. And that's one of the things I like about it, is that it is now becoming, or it's maintained a rural character since we've been here. But I think what's echoed a lot in discussions here is, you know, how do we preserve farming and do it in a way that we're not creating antagonism between the residential communities that surround these farms and the farming operation? I'm completely in favor of, you know, allowing the equestrian events, the agricultural events. And frankly, I wouldn't have a problem with any restrictions on having, you know, a wedding venue. My complaint with the way this is drafted, and I think Ms. Carver, who's left, but it was echoed, and I think Mr. Hurd, some of the individuals that spoke have voiced the same concern I have. I don't think that this text amendment is drafted is adequate to assure that we don't have disputes in these neighborhoods, that we don't have damaged property values of the residential neighborhoods caused by this commercial activity. This is not farming activity. This is a commercial activity. You know, and I wholeheartedly agree with the concept that we need to support our local farmers. They work hard. I got news for you, I'm a lawyer, I work hard too. I mean, everybody's working hard, the times are tough. We gotta all support each other. It's not just one, we're not up here to just support one narrow aspect of the community. We have to support the community as an entire community. We have to support the residential people that need to go to sleep because they have to get up and commute to New York or commute to the city. We have to support the people that work in the fields and harvest our food. So it's not just about supporting one over the other. I think one of the things that bothered me about all the comments, both for and against, is this, that we're going to take one side. I think we have to look at the town as a whole and what's going to be best for the whole. And so that's one of the problems that I have with this text amendment is I don't think that it's narrowly tailored. And I think that there's so many other more important ways to support farming in a manner that doesn't have a detrimental impact on the neighboring communities. I think Dominic had, Attorney Thomas had pointed out, that we've supported, or that we have a right to farm ordinance in town. It's a right to farm, and farming is in the ordinance itself, strictly limited to those activities that, read from the actual statute, those incident to ordinary farming operations. Farming operations, building and structures must be used primarily for the raising and incident to the ordinary farming operations. So when we keep talking about how Oxford has this right to farm, it's right to farm. It's not right to do whatever you want to engage to support your farm. You can't engage in commercial activity. You can't have a junkyard on your farm, even though that might support farmers who create extra income. There's a lot of ways that you could generate extra income as a farm. You could open up a manufacturing facility in the backyard too, or just have flat, bars or something like that. So we've done a lot in Oxford already to support farming, and the ordinance is a perfect example of that. But the ordinance relies on the general statutes of the state of Connecticut, which narrowly define farming as that language that I put in before. This text amendment, if you go back to the history of it, I think the point is well taken. It allows a lot more than farming, and I don't think it's appropriate to support the type of activities that exceed the scope of what the proponent says he's doing in supporting farming. There's a lot of unintended consequences, and I think some of the speakers talked about that. So we have a wedding venue. What about the people that want to come in and have concerts and rock concerts and rap concerts? And then we're sucked into a situation where we have to, we're going to have discrimination claims if we exercise our special exceptions in a manner that might restrict some uses to another. So I think that this text amendment is really more trouble than it's worth. And I personally am not in favor of it. I'm in favor of helping farming. I think there's things we can do with expanding the winery cider to cideries, other things, doing things with economic incentives. We can transfer development rights to the town or sell development rights in order to see, we can look into those type of remedies or solutions to support our farms. But I think that the point that I forget one of the gentlemen made, maybe Mr. Hurd made about, you're going to start creating, if you start doing the us against them, it's going to hurt farming. It's going to hurt the community. It's going to hurt farming. And if you look at this, it's a residential zone. I think there's more residential voters. There's a lot of farmers here tonight, but if the town starts to go, we have a situation like occurred in Goshen, which one of the people mentioned. Eventually, the balance is going to sway and the sympathies are going to sway, and that's not going to be good for the town, and it's not going to be good for farmers. So I would basically my position is I don't think that this text amendment is good for the town, and I think it's not structured well. If we are going to consider it as a commission, I think that we should draft it and at least have larger acreage like Tanya Carver had mentioned, bigger, more setbacks. And, the wedding venue, I don't think is necessary. I think, there are other ways in the text amendment that we can address. So I think that we might want to consider doing our own text amendment that doesn't have the wedding venue, or if it does, has very strict limitations. May to October, basically that's, the entire year when your windows are open, if you don't have air conditioning. So that the statement that, oh, it's just limited to that small amount of time, that's pretty much most of the year, most of the time when you're outdoors. So that alone needs to be addressed in the text amendment, and how we define those farms. So I would not be in favor of it. I think we should, take another look at it. That would be my comment.
Anyone else on the commission? Okay. Dominic, would you like to wrap it up?
Since I have a burden, I get to go back. I guess I'll start with the end. I don't find anything in my regulation that allows concerts. Doesn't in there. If anybody thinks a wedding venue, I don't know if any of you have studied economics. Anybody thinks a wedding venue can survive on 10 events? And by the way, it doesn't say 10 weddings, it says 10 catered ones. If you think they could survive on it, then I'd like to see how that's done, because they wouldn't be able to. You heard testimony that was uncontradicted, that there are many farms in many other towns that are doing agritarian. Commissioner Kerwin referenced the statute. So he solved one of the complaints that was made. You can't just buy a 20-acre piece of property, plant a couple of stalks and do a farm. There's a statutory definition that allows it. So somebody can't come into you to try to set up wedding venues. And believe me, it's not an economic standalone unless you have a property like THC in Durban, or you have a property like Waterview in Monroe, which is a building in which they have a numerous amounts. So yes, can the regulation be tweaked? I mean, there's a lot of comments that the regulation has no protections, that you can go hog wild. The only way anybody can go hog wild under these regulations is for this commission to decide it's not going to follow its own regulations under its special exception. That's why it's a special exception. The fact is that, again, you're not reinventing the wheel. There are farms that have non-farming activities, but they have to have farming. You think the Connecticut Farm Bureau would have written a letter to that effect? You think Griswold and other towns would have done it? Again, it's not new. Now, there has to be protections, and that's granted. And that's why that's why there are setbacks in here. They're enormous. They're quite substantial. That's why there are requirements in here for hours of operation, decibel, 10 events a year. I mean, the point about it being from May to October when the windows are open, the right to farm wasn't written, ordinance was not written to give people the right to farm. It was written to protect farms from the objections that people had when they realized that they are working farms. Now, I'm going to admit, this is not a situation where we're talking about a working farm, although I did put in equestrian competitions and equestrian and boarding for horse boarding. So when it's 90 degrees and the wind is blowing off of Lake Zor and coming down through Oxford, the smell of manure can impact people. And what it's saying in the right to farm ordinance is, I'm sorry, you can't object to that. That's just because you're living in a rural community. That's what the right to farm ordinance is about. So there's limitations on it. Can you tweak it? Yes. But if the position is farms should not have anything that's non-farming related to generate income, then you're going, first of all, you're going against the tide. Because that's what generates income. If your position is that farms in residential zones shouldn't have commercial activity, then, you know, yes, they shouldn't be turned into a commercial event, but they should be able, as is happening throughout the state, to have events to supplement their income. It would be wonderful if farms could survive selling eggs. Every Sunday or Saturday, I go to Stone Gardens Farm. Stone Gardens Farms has a very large farm market, whatever you want to call it. They have a farm butchery. They have a farm. They don't, the produce that you buy there doesn't come from one farm. They have it from multiple farms. They have it from farms. They try to help farms. So there, yes, there are ways. But do you know that there are residential people in a different area of that town who are rejecting the fact that they want to build a bigger farmers market and consolidate the farms? Because you can't survive on a 600-foot farm market selling what you've grown. That's one aspect of the economics. This is another aspect of the economics. There are things that could be changed in it. There are things that are protections, but this provides the fact that anybody that comes in there has got to show where the event area is. You realize, as I told you, of the other things that you have the right to do in a special exception, you actually have the right to locate where, if there was an event in one of the 10 events, if there was music, that you have the right to locate where that music and how that music is displayed. And that can be a requirement of the plan. And the other thing is, we're talking about this, turning this in, you know, this is going to be a wedding venue. We have catered events not to exceed 10 events a year. So they would have to, any approval would have to register. So if you had 5 of them on Saturday afternoons, or 1 on a Friday afternoon, now we're down to less number that would be in any evenings, which seems to be the objection. But you do have to keep in mind that people who spoke, unfortunately, site-specific at the last meeting, there were some that said they heard the music and others that said they didn't. But nobody should be bothered by it. So therefore, there's requirements in here that impact it. So when you look at this as a whole for the town, this is not turning 20-acre pieces into wedding venues. It's not doing that. Because you have to show your farm. So all I ask you to do is consider everything that is presented to you. And Commissioner Kerwin is correct. It's your job to address the entire community. It's your job to address the entire community in the regulation. So you heard opposition, you heard a lot of support. But when you're talking about your first step is from a planning perspective, is this something we can live with? Yes. It is not, and I don't know who is telling you it, it is not. Where if you pass this regulation, people walk in, throw their plans on your table and say, approve the wedding. That isn't approve the catering, approve it. You have a tremendous amount of ability to address the issue. Frankly, much more than you do. Somebody came into you with a 20 or 30 or 40 acre farm and wanted to put 20 houses up there. Then you don't have any discretion. So all I'm asking you to do is look at everything. Look at the regulation. Don't deal in absolutes. This is not to establish permanently ongoing commercial activities. And listen, or read everything that you can say, including the fact that you have a farm bureau, you have other towns that have done this, and they have been successful in doing it and helping to support the towns. Thank you for your time. This has been a long 2 hearings. And we have to say that being back in person is nice, although it is better when you can sit at your dining table with shorts on.
I think reflecting on Dominic's last statement about how long it's been these past 2 days, I would move to close the hearing.
Second.
All in favor? Aye. Opposed? Abstained? Public hearing is now closed. Thank everyone for your time and attendance. Please expedite clearing the room so we can get on with the regular business. Please clear the room so we can continue with our business. Yeah.
Something like that.
Okay.
They're all.
They can stay. They can stay. They just can't. Started over here, so.
All right, okay. Okay. Let's see, what do we have? We've got 2 future public hearings scheduled for Tuesday, March 15th. They're on your, and read them. Okay, are there any amendments to the agenda? No amendments. Do we have an audience of citizens? Is there anyone in the audience or online that wants to speak to something that is not on the agenda? Going once, going twice, moving on. Do we have any correspondence? No. Okay. Old business, that is where the public hearing was held? No. Old business, other matters? No. New business, scheduled public hearing?
I just have one question.
Sure.
The public hearing on the Dunkin' Donuts, that's set for April 5th. Is that on which part of the, because there were 2 applications.
It's the entire application.
Okay.
But so they need the text amendment first because they don't have enough parking spaces on their application that they submitted, so that's why they agreed to the continuance. So I think it's only two applications, right? It's a
Yeah.
Text amendment and a special exception. Yeah.
Okay.
The text amendment has to come first. Before we can consider,
You have the special exception site.
yeah.
Separate. Text amendment is the first thing that has to be.
So just
Close the
question.
public hearing.
Yeah, so the traffic study that was requested, that's a part of just the overall,
That would just be
That's
special
done.
exception, that would be the special exception.
okay,
The text amendments are irrelevant, if you think of text amendments are in terms of the whole town, so a traffic study for one spot would be useless.
okay.
He's concerned that if we don't grant the text amendment, then he's not in compliance for the special exception. So that's why they have to wait till after the text amendment is addressed.
Okay.
So we've got old business, other matters, none. New business, scheduled public hearing, none. New business, other, none. Do we have anything for zoning enforcement that's different from what we've heard?
No, just
before?
what I talked about today, the clean construction.
Yeah,
You know,
Yeah,
they
we have
came in
some.
with a special exception and we had said all your vehicles have to be registered here. So all the contractor yards right now are building their stuff, getting ready for spring. He's got pieces of equipment out there on their plates on. I notified the assessor right when she came on board.
That was a condition of the special exception.
Yes.
They registered.
Yes, I mean, John, he's got 10 brand new wagons, cranes, dozers, compressors, for all the work.
you took a bunch of pictures of it.
M&O
And that's not
Construction
the
on
only
Jackson
one.
Road, Roxbury.
All their equipment sitting there.
So I talked to the assessor today, she says, well, we gotta go from October to October, there's a statute of limitation, I'm like, can't you just send them a bill and let them fight it?
As a violation of the special exception, we can technically send them a letter saying, we're going to pull your right to have the contractor.
It's going to prove it can't be.
Unless you comply and register your vehicles in PS.
So that's something we can do.
So I talked to Mike Hurd today, Mike knows like the price of everything.
Yeah.
It's just really smart. The two companies, we came up with 5.5 million worth of personal property tax. That's just the two companies. Of equipment, the acronyms are $250 a piece, they got 9 of them.
So
That's used.
the cease and desist specifically cite a portion of the approval.
Yeah.
It's recorded, it talks about what equipment being registered here.
Just to,
So is there,
just, and this is a question as to the proper mechanism. Is it a cease and desist or is it under the provisions for violations that we actually send a notice saying we can revoke the special exception?
Yeah, I think.
Or is that done by way of a special, by way of a cease and desist?
I think it's way of cease and desist.
All right.
Because if he doesn't do it, don't worry, bring him in for a hearing, then you.
It's really just, yeah, it's.
he has some stuff on there, but I was speaking to Ashley today, and I showed her. You couldn't believe it. So there is a step, so the assessors just can't send them a bill and say, have them come in and fight it?
Well, she sets her grand list starting October 1st.
Right.
The grand list gets approved by the end of January. That becomes the grand list for the year. There can be a supplemental sent out. She can do a supplemental.
Okay, if she's telling me no, I'm saying, we did it in August. when we had property.
I move into Oxford next week. I register my car, and there's going to be a supplemental coming.
Correct.
Coming in for my vehicle for the time of the year that I'm here for the rest of the list.
I gave her this stuff a year ago, last winter, and I said,
It has, for the supplemental though, it has to be owned at the time that you file this, so he would have to register the cars with us to be able to give him the supplemental bill, or register the equipment. That's gonna require the cease and desist or the letter saying, come in, we're gonna pull your permit.
And some of the equipment doesn't necessarily get registered. Some of the equipment probably doesn't have a plate or anything like that. So then it's not registered with the motor vehicle.
it's still personal property, tax, though, isn't it?
Yes.
Personal property.
But that's when the assessor has to go out and say, you've got this.
Well, they're getting a new guy, and it's probably gonna go out and measure, but I, you
That's the
know,
gasoline that runs the town.
you know, I can take you out in the weekend, but that, because I know where every nail and board is, and they don't.
Sorry.
So that's what I was curious about. They also wanted their bond back, we told them no, they didn't finish their landscaping or anything, I said, sorry. He goes, well, I need the bond back to start my next phase. I said, you've got to finish ABC. He wasn't that cooperative. So I'd like to really, we'll talk about it tomorrow, send them a letter to come in or something. I'll email you guys the photos, you won't believe it. These things are 4 or 5 deep. The cranes are probably, how much does a crane cost to lift a bridge out? And they all got newer plates on, that's why I don't get, he's in Mayapack. Mayapack is very expensive. Or that's why I don't get, because that's where he came from. Like, why wouldn't he register his stuff here? I don't get
Because
it.
he probably took it out of there, it's off their tax rolls, but not on ours.
Oh, yeah. Probably right.
Looking for a little breathing room.
Yeah, okay, let's move on then.
Yes.
Okay,
I'm just gonna table those.
the table of minutes. Motion to table the minutes from 12/7/21.
So moved.
All in favor?
Aye.
And the minutes from 2/1/22.
So moved.
All in favor? Aye. All right, now we got other business. Refer to council, the Riverview Drive, Lars Realty, that's still working on that. The Hunters Mountain Road thing is still,
We're still waiting on
wetlands, and actually with the DEP, I guess is involved in this.
And no wetlands hired a new soil engineer to look at, what they think maybe a vernal pool up there. The only time you can tell that's a vernal pool is in the spring, so they're waiting.
Yeah. Okay, Riverview Estates, bond release and acceptance of road. Where do we stand with that? Riverbend.
I sent that to Jim now.
Oh, yeah, that's
Oh,
right.
that's sent to Jim, obviously, we're waiting on Jim. And, okay, this is important. The opt-out process for the land use registration. Okay, the new legislation, I think there's 3 or 4 things we could opt out of. And what I'd like to do is, again, send another letter to the Board of Selectmen. If that's okay with the commission.
They just need to
Hoping them a
give
bit to
some
get that
direction
done.
on those 3 topics.
Right.
And
And if
and
there's
again,
something.
Pat, it's important that we put on the record that we haven't judged it one way or the other.
Oh, absolutely.
Yeah, but it is, time is running, whatever we're gonna do. So I'll move that if we need.
Yeah.
Second.
All in favor? Aye. Opposed, abstained, motion carries.
Who seconded that?
I do. Okay. And there's any other items the commission needs necessary for discussion?
I just have one question. The budget,
Yeah.
when is the budget meeting with the Board of Finance?
We didn't get the schedule yet.
We didn't get the schedule yet, and we haven't even had our meeting with the Board of Selectmen yet, which is something that,
Well, a few other departments have already done that.
yeah, I want to bring this up. I would like to, when we have to, go in with the, Board of Finance, Board of Selectmen, have a couple of other commissioners also attend, so that we can, you've all seen the budget, and helps justify.
Historically, that was always the vice chair. It's history. We don't have a vice chairman.
But the,
I'd like to be notified though either way when that meeting is,
because,
or meetings.
they tend to, just cut, numbers. They're being counts. They look at numbers. They're not looking at the why. So we have to be there to tell them why.
Yeah, let me know if I'm available.
Yeah.
I mean, usually they don't let anyone else talk except the chairman. They don't
Okay.
let staff in, and they don't let anyone else in except the chairman. They have it in the text. Remember we talked about this
Yeah,
that
unfortunately,
last
they're
night?
not gonna
So
fly.
I suggested in the motion, I
I'm
suggested
not,
that
yeah, I'm not
the
even
commission,
making a motion.
you're not,
because I'm
okay,
gonna-
Brad, all right, all
No,
right.
I'm saying, I'm gonna show up whether they like it or not, because it's a public meeting.
Well,
And
that's
they
right. we did have
cannot,
this.
they cannot deny you access to a public meeting.
It's all coming back to me now.
So I'm not even gonna make a motion, I can't, because there's no motion necessary.
You're right, you're right. This is all coming back to that. So,
I'm sorry.
Mr. Chairman, I saw on their agenda that they were finalizing their budget schedule last night. I think it was, last night was the fourth Monday of the month. So if I can get a hold of that, I will send that right out to you.
I'm not taking it out.
I know you're not,
But
I know,
don't
but I do remember
like-
this play. I remember this version of you. I remember now.
I guess that's the last thing.
The in-person meetings you want to talk about,
Oh, yes.
or the road.
Because of the terrible acoustics in this world, people really can barely hear us. What I would like to do is suspend the online meetings until they repair the acoustics in this room. Maybe, people can listen in, but no virtual participation, if you know what I'm saying. Because they can't hear what's going on. I mean, I've attended other meetings in this room with these things. Very.
When I've gone back to listen to the record.
Right.
Complete reverb.
And we're allowed to go back to full-time.
We can.
Oh.
That's what I was
Or-
gonna ask the attorney
Yeah.
materials, the executive board, I know some were extended that provided for online participation. Has that been terminated or is that still?
I don't think it's been extended, but I think anything you started as an online application and started a hearing, I think you have to finish it that way. I think going forward, if you open up a new hearing, you want to announce that it's going to be live only, and it's not going to be Zoom.
Well, we've closed the public hearings that we have, right? There's nothing on the table now.
Dunkin' Donuts.
Special exception on Dunkin' Donuts.
Yeah, but there's no public participation going forward at this point, since it's not closed, right?
Both of the public hearings are closed. The special exception is still open for comment.
That public hearing is still-
Okay.
Yeah.
So
That's the only one. We can do. Just let that be. Limited to that, and we notice it closed off.
Right.
Are there any plans to fix this?
Yeah, supposedly they're gonna carpet this room.
Have we noticed, and then Jessica will tell us, have we noticed the two public hearings for March 15th? We've noticed them as public.
Tomorrow it's going into the voices tomorrow and the night, and it has the Zoom link.
So you,
But the next one.
So from here on,
After the 15th.
Because like I said, I don't want people listening in.
Yeah.
But participation over them.
Why don't we close at least the back divider to at least make the room smaller?
Yeah, and a night like, unlike tonight, we could close it, we could even close this one.
Yeah,
It's a
we've
lot
done
better.
But they're supposed to get carpet this, which is absurd. And just for the record, planning and zoning bought these chairs. From our budget.
I don't know where the wheels are.
What?
I don't know where the wheels are now.
That's the thing. Inform the board of selectmen, I want my wheels back. Especially if they carpet this room, I want my wheels
Right,
back.
then the wheels would go ahead.
What?
I think the wheels will move after.
After, yeah.
They almost
That
A couple of people did.
Well, George.
So George, actually, it's one.
But anyway, I mean, I find it very annoying not to have the wheels up there. And if they carpet this room, it's gonna be impossible.
You find it annoying until you find yourself looking at
I'm
the ground.
76 years old. I didn't have a problem sitting down or standing up in a wheelchair. So let's be realistic.
You know, did you have any problem? Yeah, there you go. So there's the extreme. There's the extreme right here, right? Everybody else falls in between.
Motion to adjourn?
All in favor?
Aye.
Thank you.
Okay.
Are we offline?
Wait, hold.